Good morning, good afternoon, and good evening, everyone. My name is Ina Ergasheva, and I'm the Director of Operations at the Canadian International Internet Dispute Resolution Center, or simply CIIDRC. It is my great pleasure to welcome you to today's webinar on key UDRP cases of 2024, featuring cases selected by our esteemed panel. It is fantastic to see such a diverse audience joining us from across the world. CIIDRC or CIIDRC is a division of the Vancouver International Arbitration Center, and we had an exciting year of growth. In 2024, we saw a 25% increase in domain name disputes, a strong testament to the trust the global community places in our services. Last year also marked CIIDRC's 5th anniversary since being approved by ICANN to provide dispute resolution services under the UDRP. Our over 20 years of service under CIIDRP continue to enforce our position as a preferred domain name dispute resolution center in Canada. This growth is a reflection of CIIDRC's commitment to delivering efficient, neutral, accessible, and fair dispute resolution. Today's session will highlight some of the most interesting UDRP decisions of 2024, carefully selected by our distinguished panelists. And it is my great pleasure to introduce them in alphabetical order, starting with Bart van Bezien. He is a leading attorney and arbitrator in intellectual property law, copyright, trademarks, patents, internet and media law, domain names, e-commerce, advertising law, freedom of expression, privacy law, and art law. He has practiced law since 2001. Both in his home country, Belgium, and other jurisdictions. Bart was a panelist in over 100 domain names proceedings under the UDRP, URS, and CCTLD's disputes policy as a sole panelist, presiding panelist, and co-panelist. Bart has worked as an attorney, as a corporate lawyer for an IT company in Ireland, and as a university researcher. In total, he has rendered around 100 domain name decisions. Now, next one, we have a great pleasure to have again with us Maria Alejandra Lopez Garcia. Is a Venezuelan lawyer, industrial property agent with more than 20 years of experience in distinctive science and domain names in the public and private sector, nationally and internationally. She has successfully studied intellectual property at the Metropolitan University of Caracas and at Alacantes University. She was a part of the legal team of the WIPO Arbitration and Mediation Center, administering more than 500 UDRP and CCTLD procedures in domain names alternative dispute resolution. Since 2017, she runs her own firm, IPRs Online, focused exclusively on the solution of intellectual property rights infringements on the internet. And Alex has been a part of our list of UDRP experts since 2020. A position she carries with enthusiasm, commitment, and impeccable professional ethics. Next, we have our own Canadian, Zach Moscovich. Zach is CIIDRC panelist and a lawyer in Toronto. Since 1999, Zach has acted as counsel on behalf of both complainants and respondents in over 100 contested UDRP proceedings and other national domain dispute mechanisms, including the CIIDRP. Zach was counsel in several of the earliest precedent-setting court cases in Canada involving the intersection of trademarks and domain names, such as Toronto.com, versus Sinclair, Black versus Molson, Cheap Tickets versus email.ca, and East Haven versus Nutrisystem. ZAC participates in internet governance through ICANN's business constituency, in ICANN's Right Protect Mechanisms Working Group and the Transfer Policy Working Group. ZAC also writes about interesting UDRP decisions in the weekly ICA UDRP Digest. Make sure you subscribe. You will get a great pleasure of his insights. And last and not least, we have our panelist from Germany, Munich, Peter Müller, is a German-based IP attorney and a certified IP lawyer. He concentrates his practice on the area of industrial property protection, in particular in relation to the internet and all kinds of domain name disputes. He is represented parties under UDRP and various alternative dispute resolution proceedings for CCTLDs and in proceedings before the German courts for over 15 years. He also regularly publishes on domain and trademark issues. Now with that, let's dive in. We will begin with Peter, who will cover the topic of UDRP out-of-pocket costs. Peter, the floor is yours. Virtual floor.
Perfect. Thank you very much. Do you have the slides?
Yes, we can see them.
Thank you. Okay, good morning, good afternoon, everyone. Thank you, Ina, for the kind introduction and for having me here today. I'm very honored to participate on this webinar and to discuss two recent decisions covering the topic of out-of-pocket costs under the UDRP framework. Over the year, the panels have generally been consistent in supplying some kind of standards with regard to bad faith by offering a domain name exceeding the documented out-of-pocket costs. And we have now two decisions from 2024, one of which is consistent with the previous case law and one of which is, in my view, some kind of very, very different and might also raise additional issues. I will first provide an overview of the case law from the last decades somehow, all focusing on slightly different issues. Then we have two decisions from 2024, one of which is in line with the previous decision and already mentioned, one is not. First of all, we have the legal framework. I think you all might be aware of the wording of policy paragraph 4BI, which is one of the examples for a domain name owner who is acting in bad faith, namely if he is offering a domain name for valuable consideration in excess of the documented out-of-pocket costs directly related to the domain name. So there's in this wording we have a lot of different possibilities and a lot of different terms which a panel has to go after if it wants to find bad faith under this paragraph. And first of all, I think these out-of-pocket costs is always to be seen in some kind of a cyber squatting issue. If you are a domain broker and you buy domain names for thousands of dollars and you are selling domain names for thousands of dollars, this might not be the case which this paragraph directly addresses, because if you are registering domain names legitimately for resale, it might not be a classic cyber squatting case. So I think we have to first of all exclude the cases where substantial amounts are paid for domain names for resale. This might not be relevant under this provision. The old decisions are some kind of collected, go back to the 1990s. One of the first domain name decisions was worldwrestlingfederation.com. The price tag was $1,000 US, and the domain name was transferred, and the panel found that this was above out-of-pocket costs directly related to the domain name. So this is some kind of straightforward with regard to the wording of the policy. I just have a lot of examples to provide you with different wordings in the decisions, so that we can see that there's already some kind of inconsistency here in the previous case law. The next case is from 2011. We also have documented out-of-pocket costs directly related to disputed domain name. Price tag was 10,000. And we have a decision just referring to out-of-pocket costs, not documented out-of-pocket costs or anything else, which is a little bit a shorter version of the finding. Price tag was 1,690 euros. Another decision, so it's just different wordings. It's all the same. It's always, in most cases, no response, price tag beyond 1,000, whatever currency, and no explanation whatsoever from the respondent. So it's pretty easy to go this way for a panel and to decide that it's bad faith under this paragraph. We have a decision speaking of considerably in excess, so there's a minor difference between the other wordings. This is pretty interesting because the respondent claimed it bought the domain name for exactly this price and just sold it for the same price again, or tried to sell it for the same price. This is nothing I'm very familiar with, because nobody usually pays these amounts just to resell it for the identical price without making any profit. So maybe he was contacted by the complainant and told him that he paid 2,500 itself for the domain name and wanted to have this amount reimbursed. This might be the case here. And the panel found that even if the respondent paid this amount for the domain name, this is still far above the registration and renewal costs. So we have a different wording here, referring not for the documented out-of-pocket costs, which shall cover a purchase price as well, but we have registration and renewal. Another issue, another decision, which simply refers to registration costs. We also have cases without specific price tag. In this case, the respondent asked, the panel found that it is fair to conclude the respondent would not have accepted an offer to recover his out-of-pocket costs. So it's some kind of a, trying to read something in the complainant or in the response, which might been there at some point. And the last example I have is a case where the respondent asked for subscription fees for its server for 1 year. And the panel also found that this was in excess of the out-of-pocket costs in this specific case. So we already have from the past case law very different wordings, and resulting therefrom, I think already have some problems especially for the respondents, when they have to determine which price they can actually ask for the domain name. We have any out-of-pocket costs, registration costs. We read about renewal costs. I'm not quite sure if the purchase price of a domain name is documented out-of-pocket costs or not. We do not know if we can also claim renewal fees. So we have already until 2024, we had a lot of decisions slightly inconsistent, but all referring to this specific paragraph of the UDRP. When it comes to the 2024 cases, we have first case, which is pretty in line with everything we heard before. Asking price $300, which is really not much cheaper than at a UDRP proceeding or whatever. But the panel still found that this is more than the out-of-pocket costs. So usually there is no bottom line where you're safe. You can ask for $99 and panel still finds that it's out of pocket because the .com registration is about $12 a year. So there's no bottom line, but we now have one decision actually, and this is the main decision I wanted to point you to, because it's very different from what we read before. Sorry, I just slipped the slides. The decision was rendered by Alan L. Limbury, which is a very esteemed and highly experienced UDRP panelist. And I'm perfectly sure that he's aware of of many of the precedent cases and all the issues already discussed under the paragraph 4AA. And he decided that $3,000 might be in excess of the documented out-of-pocket costs, but, and this is the new thing, he speaks about the value of the domain name for the complainant, and states that 3,000 is unlikely to reflect the greater value to complainant. So he's not going simply after the numbers of the domain name and the price tag, but he has some kind of discussion in between the interests of the parties and discusses why the complainant might have a interest in the domain name which is higher than the asking price. I think this is somehow problematic because we have to talk about the question whether the asking price has to reflect the value to the complainant or not, and this is merely subjective, an issue which the panel can, from my perspective, not decide for itself, because the complainant for the value is pretty subjective to the complainant. And I see a big issue here because in UDRP complaints, the complainant has often to prove that he is some kind of well-known, that the trademark is well-established, that he has international business relations, just to prove that the respondent acted in bad faith, which he always does if he has knowledge of the trademark. So the complainant has to bring forward many arguments that he's famous, just to prove that the respondent had of course been aware of the trademark. And then in the same argumentation, he rises the value of its trademark up to a certain limit, and then all the argumentation with regard to bad faith registration might infect the value of the domain name for the complainant, and therefore the price tag, which is legit. So I think this is an issue which is not that easy to handle for the complainant side. And on the other side, it's for the respondents pretty hard because the panel has always the possibility for subjective evaluation of the case. And so each and every case can turn out very different depending on which panel you have, and if the panel lives in the country where the trademark is famous or not. So I think we have some kind of inconsistency issues here if we would follow this jurisdiction, and therefore I'm some kind of skeptical if this is the right approach, because I think that we are in need of some kind of clear standards to keep the UDRP a reliable basis for comprehensible decisions for both parties, not only for the complainant side, but also for the respondents. And we have to have some kind of clear standards for the panels as well. And we already have problems when it comes to the facts of the case. And I think we even get more problems if we open the UDRP for this kind of personal interpretation of values of a domain name for either of a party. So this is my point at this decision, and that's why I wanted to bring it to your attention. And I think that's it for me. Thank you very much.
Thank you very much, Peter. Not often we hear presentation on this particular topic. And I forgot to mention at the very beginning, the audience, and we have right now with us more than 40 people. Please feel free to ask questions via chat or via Q&A section, and we will be more than happy to address your questions. Again, thank you, Peter. Very interesting presentation. And now we will move to Bart. Bart, the floor is yours. You are on mute, Bart.
Yes, thank you. Just 1 second. I will share my screen. I'm sorry, I'm trying to share my screen. It worked when we tried it. Just 1 second. Oh. I'm sorry, I'm trying to share my screen, but maybe, Ina, if you can present, that would be helpful. Okay, so I selected 2 cases for you. You can go to the next slide. Yeah, next slide. Yes, thank you. So the first case is, well, it's what we call a consolidation case. The complainant was the German Deutsche Börse. They operate the Frankfurt Stock Exchange and also Eurex, which is a German derivatives exchange, and they own many trademarks. Eurex. Now, these domain names, in fact, there were 49 different domain names, all included more or less the name, the trade name, the trademark Eurex or misspellings thereof. So the complainant, Deutsche Börse, but there were 14 different respondents, and that is always a difficulty in these consolidation cases. These cases are started when the information details about the owners of the domain names are not always known, and so the complainant starts this case, finds that there are reasons to ask for a consolidation. Maybe if you can go to the next slide. So the complainant mentioned in its request that while all these domains were registered within a short period of time, well, in fact, a 3-month period, all the domain names had the same structure, the trademark or misspellings thereof, and then addition of always similar terms, and they were all used for similar financial or trading websites. Now here, the quite exceptional situation was that one of the respondents actually submitted a response. In my opinion, in these consolidation cases, it happens quite a lot that there is no response submitted at all. And here we had one of the respondents who owned 31 of the 49 domain names, admitted that it controlled these 31 domains, but not the other domains. And the question was then for the panel whether or not to grant consolidation for the other domains as well. And I think that the panel did a good job here. The panel said, well, we accept consolidation for these 31 domains, where the respondent confirmed his control, but not for the others. Now, the panel also mentioned that in case there would not have been a response, the complainant's arguments would likely have been sufficient for a full consolidation. And I think that that is a reality. But I always find it strange that the amount of time and energy that we as a panelist invest in just managing one domain name case, if you compare that to the quite easy acceptance in many of these consolidation cases, easy acceptance of the request to consolidate, I find that quite striking and surprising. And I think that as a panelist, we have to be careful with the reasons to accept a consolidation case, and especially because quite often there is not a lot of information, and quite often the complainant actually puts a lot of the homework on us. And as a panelist, you have to do a lot of research instead of the complainant doing it. And I don't think it's a good situation. But so here in this case, the panelist said, well, these 31 domains, admitted by the respondent, all registered in the same 3-month period, same kind of website, etc. Next slide, please. So the key arguments of this domain name case then, well, the first test, the trademark was recognizable in each of the domains, so that was quite obvious for the complainant. Then a rights or legitimate interest, the second test. The interesting thing here was that the respondent admitted that it had used artificial intelligence to identify the domain names for registration, and also used AI to create websites for these domain names. And all these websites were used for similar services as the services offered by the complainant, some kinds of financial services, trading services websites. And interestingly, the respondent did not explain why the content of these websites was similar to the services offered by the complainant. And so the panelist decided that, in fact, the respondent intended to take advantage of the complainant to redirect internet users to its own websites. So the second test was also for the complainant. And then the third test, bad faith. Interestingly, the question of using artificial intelligence and making artificial intelligence tools make decisions, make choices, make the selection of the domain name and of the content on the domain name. You could ask yourself whether it is then bad faith of the respondent, of the owner of the domain names, but the panelist decided that that the use of this artificial intelligence tools did not matter. It was still the respondent's responsibility, the intention of the respondent, and I think that that is a correct decision, of course. So the bad faith test was also decided in favor of the complainant. So I think that this was an interesting case, not only because it concerned a consolidation case, and because this panelist made a prudent decision in not including the other domain names in the consolidation decision, but also that in combination with the use of artificial intelligence and confirming that use of artificial intelligence can still lead to the respondent's liability under the bad faith and test was definitely interesting. Next slide, please. So my second case that I selected is a WIPO case concerning the domain name alhambra.com. The complainant in this case was a public authority in Spain, Patronato de la Alhambra, Il Generalife, if my Spanish is correct. It's a public authority that manages the Alhambra complex, and the Alhambra complex is a very well-known monument in Granada, which is a city in the south of Spain. It's very famous. It's a UNESCO World Heritage Site. They receive around 2 million visitors each year, and they also have a lot of trademarks. It was not very clear in the decision itself, but in between the lines, I believe that they invoked no less than 68 registered Alhambra trademarks. And the panelist made an explicit reference to an European Union figurative trademark registered in the year 2011. Now, the respondent was a domain name investment firm from Malta. They acquired the domain name in December 23, but the domain was actually created in August 2000. Now, they acquired the domain in 2023 along with 197 other domains, and these other domains did not contain any explicit references to well-known registered trademarks. Next slide, please. So this is just for your information, a beautiful picture of the Alhambra complex. In fact, I have been there quite a couple of times myself. It's one of the most well-known monuments in Europe. In fact, if you want to buy tickets for the Alhambra, it's not clear which website you have to use. If you just search on Google to purchase tickets for the Alhambra, you will end up with many websites offering tickets, and the prices really going from just 20 euros to sometimes a couple of hundreds of euros. And so I understand why this complainant started this procedure, definitely. And at first view, I thought it would be a clear case, very well-known trademark. And also, if you go to the next slide, please. Maybe I start with the first element. There was an identity between the domain name and the Alhambra trademark. The respondent admitted this, and so this was definitely for the complainant. Next slide, please. But then the second and the third element are interesting, I believe. The complainant did its homework, and they started with a good chronology. And I always appreciate it as a panelist that there is a good chronology and that the parties list what happened at which specific point of time. And so the complainant stated that, well, the respondent registered the domain name in 2023, clearly after the UNESCO World Heritage status, which was from 84. Also after the complainant's creation in 85 and after the complainant's trademark registration of 2011. They also claimed a publicity budget, a yearly budget of 120,000 euros, but they did not provide details about how they spent this budget. And then some general arguments that they don't have a relationship with the respondent, etc. And importantly, they submitted a screenshot of the parking page, which mentioned a simple sentence: obtain this domain. It linked to a page where the domain was offered for sale for a sum of 6 figures. And there were also pay-per-click links. Next slide, please. And then the respondent did also do its homework in terms of the chronology. And interestingly, the respondent stated that, well, yeah, this Alhambra complex precedes the complainant's creation by no less than 800 years. And that's also important. And the reputation also predates the reputation of the monument predates the creation of the complainant itself. And interestingly, as an argument, the respondents said, well, yeah, you have to make a distinction between, on the one hand, the renown of the monument, and on the other hand, the renown of the complainant or its trademark. That's not the same. And in fact, and that is also a very good argument, I believe. In reality, there were many other parties that used the name Alhambra. And the reason is that this is such a well-known monument that in recent history, many other parties in different countries have used this name, for instance, theaters, but also cities in the United States, for instance. Concerning the 68 Alhambra trademarks invoked by the complainant, the respondent added that, well, other distinctive words were added to these trademarks. There were figurative marks, etc. But the most important argument that they used is that, well, in fact, it's a generic name. They said that they were not aware of the complainant when they registered the domain name. They did a Google search, and apparently there were many parties using the name Alhambra. Next slide, please. As concerns the third element, bad faith registration and bad faith use, the complainant stated that the respondent must have known about complainant's reputation at registration, that there was a risk of consumer confusion, etc. But interestingly, the decision did not provide many details about the complainant's bad faith arguments. And for instance, the sum asked to purchase the domain name, the 6-figure sum was mentioned under the second element instead of the third element. Next slide, please. Then the respondent, the respondent interestingly said that the screenshot of the parking page that was submitted by the complainant actually predated its acquisition of the domain, and that there was no date mentioned under this on the screenshot, and as well that the name Alhambra is a generic name, and that the respondent never solicited the complainant for sale of this domain. Now, let's have a look at the next slide, what the decision was then of the panel. Well, interestingly, the second element, rights or legitimate interest, was not addressed. And then, we can go to the next slide. Of course, it depended on the bad faith, and the decision was for the respondent, in the sense that, and I think it's interesting, well, the first element that the panelist took into account was that a worldwide notoriety based on a marketing budget of only 120,000 euros, that was not sufficient proof. I don't know if that is entirely true or not, but the important thing there is that, well, it is the complainant's burden of proof, and often complainants, forget about it. It all depends on the proof that the complainant can provide. Also, the second argument, that you have to make a distinction between the notoriety of the monument on the one hand and the notoriety of the trademarks. At first, At first, I thought that it was a little bit of an artificial argument, but on the other hand, if you look at the trademark that was invoked by the complainant, interestingly, this trademark did not have a lot of, well, the classes selected in the trademark application, they were not well related to the monument itself or to the tourist services linked to the monument. The trademark was registered for all kinds of different goods and services, but not so much related to the monument itself. So, and in that sense, I think that the distinction made here by the panel is a correct distinction. In fact, the notoriety of the monument does not necessarily equal the notoriety of the trademark, and that is also an important element of fact. I personally believe that it's perhaps a second element discussion and a third element discussion, but of course they are linked to each other. And I believe that the most important argument here was that the term Alhambra can refer to many parties, even if this is a worldwide known monument. The name is used by third parties as well. And so there is, it's well possible that other parties and as well the respondent may have rights or legitimate interest, but this is something that was treated under the third element. And also interestingly, the price of 6 figures, the sum asked for this domain name, the fact that there was no date on the screenshot is an important element of fact. And often, I see that often when I have to decide on a domain name case, that there is a problem with the screenshots, that there is no date on it, or that even the URL is not mentioned and things like that. And I think that as a panelist, we should take that into account. The respondent, added proof that this screenshot actually predated its acquisition of the domain name. And the panelist reproached the complainant for this, and I think that they were right to do so. Next slide, please. Yeah, so this is my last slide. Well, in fact, there have been other, what I call then monument cases, and they were referred to by the parties. And the panelists said, well, okay, the difference between these other monument cases is that in these, like one was a domain name, tourefelltower.com, another one was mesquitadecordoba.org. So the first one concerned the Eiffel Tower in Paris, the other one concerned a mosque, a very famous mosque in Cordoba in the south of Spain as well. There, the panelists said that, well, the reference to the monuments was definitely a reference to the operators of these monuments. And that was a difference with the current case, whereby, the name Alhambra can refer to many other parties as well. There were other previous Alhambra decisions as well, but they were considered irrelevant, but I will not go into the details there. And then the panelist confirmed as well that the policy is only for obvious cases of cyber squatting. That is often mentioned in domain name decisions, and I think that's correct. The question is always, what does it mean? And of course, the parties, and especially the complainant, is allowed, of course, to enter a court case in Spain if they think that these facts infringe trademark law, Spanish law, but that is beyond the scope of the policy. Thank you.
Okay, thank you very much, Bart. Very informative and insightful. And now we are moving forward to Alejandra Marcial Garcia. Alex Lopez. Yes, Alex, please.
It's okay. Yeah, very interesting insight, Bart. Certainly, Yes, so I think that we're going for, but at the end, Alhambra.com was transferred. That was my concern, my question. Bart.
No,
wasn't transferred. Okay,
no.
yeah. It reminds me Casa Batlló, you know? Well, I think it was a case from 2009, but I think at the end was transferred for Gaudí, the Gaudí, monument. Yeah. Okay, so this is a very different topic, but yeah, given an experience that I had with certain cases, I decided to bring this analysis and relation with porn squatting and a case of impersonation that at the end you will see that is my own experience with how it was my own experience with it. So this is an index in relation with how my representation, the course of my presentation, a little bit of an introduction about pornography, then porn squatting, UDRP cases, specifically or most and in relation with how the third element has been addressed by panelists, and usually how it has been considered by them when there is adult content in the website by respondents. Leo list cases, an experience of impartiality for myself, and final reflection in relation with XXX.adult.sex and .porn. Okay, so if we take a look at this, well, in my view, beautiful piece of work art, we can see that, well, since the beginning or since the inception of humanity, sexuality requires to be expressed. Depends of any kind of the media available at the time. But certainly, even in social networks, some of them I understand that is X, that recently has updated its policies and in relation with adult content, allowing it. But at the end of the day, what we can see here is that, yes, this can be a piece of art. We probably feel more comfortable when we see that sexuality is expressed through art. Here we can say that yes, it's adult nudity, of course. Also, but what about it? Can we consider it as porn? I'm sure that many of us are not going to consider it as pornographic content as such, but why? What is the difference? What makes pornography? How it is distinguished? So there is a universal definition for pornography. There is not. There is not a uniform definition for it. Given the differences between, of course, between cultural backgrounds, legal perspectives, and also because in dependent of the jurisdiction, it will be the right to pleasure will be there, and also will be part of the freedom of expression. And we can see that, for example, in the United States. But there's always going to be pornography should be expressed with certain boundaries. But at the end of the day, yes, well, a general definition of pornography, according to my research, can be defined as sexuality explicit material intended to cause sexual arousal. But is it legal? It depends. It's up to the jurisdiction. Okay. And if it's up to the jurisdiction, it will be always, but always with certain limitations or key legal considerations, which should be the consent and age, also related with obscenity laws. But at the end of the day, what it brings it with this topic, and it is that in terms of pornography on the internet, is that it faces significant challenges given the jurisdiction. The global nature of the web makes it difficult to implement laws that they are effective in all countries, and many sites may operate from jurisdictions where laws are less stringent. But at the end, porn is a problem. Well, it would be up to the jurisdiction, as I said. In certain jurisdictions, it's part of a freedom of speech, but not obscenity. So, panelists, when you review the jurisprudence in relation with this type of cases, you will see that panelists usually address the third element and define it as obscene content. It could be even considered by others as offensive. They can tarnish the reputation of a trademark owner. It can be also, of course, falling into paragraph 4B4 of the policy as an evidence of bad faith use, and of course, because targets the complainant's trademark. In cases, according to my research, in cases, WIPO cases, we can find how it has been defined. For example, well, when in terms of when we talk about porn squatting. In 2001, a panel mentioned that the content was considered as unacceptable. So a very elegant, in my view, very elegant word used to that. Unacceptable use of the domain name when a respondent associates the complainant's trademark with pornography against his wishes. Then in 2009, in this case, this is the first case what I found, at least according to my research, what I found when the word, what we can understand and we define today in English as porn squatting, it was defined at that time by porno squatting. A case with Prada S.A. versus Roberto Baggio. When it decided that, it mentioned that the facts of this case constitute a classic example of porn squatting, in which confusion with a well-known trademark is used to divert consumers to a pornographic website to commercial purposes. Then in 2021, we find that another definition of porn squatting as the practice whereby confusion with a trademark is used to divert internet users to a website with pornographic content. Here, in relation, this is not a porn squatting case as such, I believe, because I of course I didn't have access to the evidence as such. But for many of you, I understand that this rabbit must be very well known. Of course, even Andy Warhol dedicated a piece of his amount of his time to draw this logo, this well-known logo. We talk about here in an industry that, yes, it's dedicated to adult content, but at the same time, it's not only dedicated to that, but it has developed other commercial lines in relation to the adult content that in the end is the same, but there is a trademark built around it. And Playboy is recognized as a well-known trademark. And also, well, sorry, in relation with that case, it was a case of impersonation, and at the end was addressed also as the panel considered that the respondent has targeted the complainant by using the same logo and trying to imitate verbatim the content of the website of Playboy's website. Another company that I believe in my view acquires more relevance or use, or at least I know this trademark from I think it was during the pandemic, who acquired more use in 2020, OnlyFans, which is again a company that is also dedicated in part well to reproduction of different videos where users can upload their own content, and they are promoted in any area that they want. But also, it's in my view, I would say that OnlyFans is also a well-known trademark that that yes, that also runs the part of the adult content in the online online. Sorry. Then here we can have another example of this, in my view, will be an example of porn spotting as well. This is Nestlé. I'm sure that most of us are well aware about this trademark, Nestlé versus Love Nestlé. This is a case for CAC, the Czech Republic provider. This is a very recent decision. Composed by 5 domain names, where one of them was used by the promotion of the sexuality, explicit woods, in this case were sexual sex dolls, which I leave it up to you, to your imagination, how the website looks like. But in this case, the panelists, who did a very interesting job, and in my view, said that use of the disputed domain names in connection with the sexuality explicit woods could tarnish the family-oriented image of the complainant's trademark. The story behind the Nestlé logo, if you can see there, these birds who have his own, it's their own type of birds, as far as I understand. But it's a father or mother bird feeding their own the little birds. So that's the intention of the image behind also Nestlé, and part of the long story about the logo. But then 2024, 2 cases arrived to my hands related with Leolist trademark. Part of that I will say that what was the business of the complainant. So the complainant identified has his own trademark. It was a European trademark, registered since 2021. In my view, Paul was a young trademark, but it seems to be that according to the numbers, up to by 2022, up to 30 million visits received per month. So yes, it was known. But this company provides online platform services through this website, leolist.cc, for anyone to post and respond to classified advertisements in Canada, and focuses on listings for dating and companionship services. Okay, so then what it calls, that's why I brought this, I decided to bring this case, because also it calls my attention how the respondent uses of in this case, it was, there were individual cases, they didn't request for consolidation, who calls my attention, but at the end of the day, it was received like that. But the respondent uses the disputed domains names in the exact same way that it is by the complainant, up to the point that the difference between them seems indistinguishable. So then I found myself wondering, wow, the complainant's business activity resolved to be not indifferent to me. So what to do? What can I do? So at the end of the day, after reviewing all the evidence, and of course considering above all the impartiality and independence that we already accept the case, and that we already are engaged into it. But then I reviewed again my impartiality, and I questioned myself to it. But at the end of the day, I was able to be completely impartial and find and decide objectively based on the 3 elements, because the 3 elements were there. So the 3 elements are met. So at the end of the day, it was possible to render a decision. Again, this was a case of impartiality, but it was not indifference. Was not a case of indifference to me. Also, makes me wondering why, or is it possible that in terms of adult content, it's possible that certain trademark owners can consider it to address these websites through, this is just a suggestion, okay? But to IAMS, through ICM registry, where they are already available for GTLDs who already targets the audience that is .sex, XXX, .porn, .adult. I'm not so sure how successful they are, but I understand that they are there, and I'm just wondering if it was possible. So this is my presentation. If there's any questions, I'm here, and thank you very much. Okay, so I think the next one, the next round is for Zach. Thank you.
Thank you very much, Alex, for your perspective. Zach, and Zach will provide his final presentation on reputation and targeting.
Sure. Thank you so much, Ina. Thank you for having me. And thank you, Bart and Peter and Alex. Very informative presentations. I know we're pressing against the end of the hour, so I'm going to try to keep this as short and succinct as possible while still covering the case that I want to share with you today. So I'm going to begin by sharing my screen. And of course, that button is right here. 1 second. There we go. Can you see the the screen? Okay. All right. So the case I'm sharing with you today is a CIIDRC case, and you'll see it's from August from 2024, and you'll see the panel, 3 very, very experienced CIIDRC panelists, and you'll see the domain name chronosgroup.com. The reason I selected this case is because it brings forth what I consider one of the most fundamental issues, if not the most fundamental issue in the UDRP, and that's reputation. Why do I say reputation is perhaps the most fundamental issue in the UDRP? Because if you compare trademark infringement to bad faith registration or cyber squatting, trademark infringement of a registered trademark, if you have a registered trademark, it doesn't matter whether someone's heard of your trademark or someone intentionally infringed your trademark. If they're infringing it, that's infringement. Cyber squatting, bad faith registration is understood by the UDRP is a little different. It requires bad faith, and bad faith requires some element of knowledge of the complainant's trademark. Knowledge or awareness, that means that the respondent must have some awareness in order to even be seen to have targeted the complainant's mark. Without some awareness, and sometimes that can be willful blindness, there can be no targeting. And targeting is what's required under the UDRP to show bad faith. This domain name was registered March 3rd, 2023, recently. The complainant is a cannabis company called Chronos Group. You'll see that they selected the domain name thechronosgroup.com, ostensibly because chronosgroup.com was already taken. Well-known company in some sectors of society. New York Times has covered them. They've received media coverage in many other major financial newspapers and magazines. They're a publicly traded company in the TSX and another exchange as well. They have registered trademarks. Here's their Canadian registered trademark, filed in 2017. You'll see for a bunch of services and goods. Noticeably, they didn't actually apply for marijuana itself, and that's because Canada didn't legalize it until after they had applied for the mark, and so these were related services, just an interesting side point. The complaint alleged that the respondent registered the domain name years after the complaint's trademark. That's true. The respondent had a history of registering trademark abusive domain names. The respondent acquired the domain name for the purposes of selling to the complainant, offered it for sale for $48,500, and then in the course of negotiations offered to accept $18,500. So, more than the out-of-pocket expenses that Peter was discussing. And the website was a GoDaddy brokerage page, as you can see here. This is a list of the cases that this respondent had been involved in previously. You'll see complaint denied, but you'll also see some transfers. This is UDRP.tools. And so if you're not using UDRP.tools, I suggest you take a look at it because it's a very, very robust search engine for UDRP cases, much more robust than you'd expect, and it gives you a great ability to search through cases to find exactly what you're looking for with many search parameters that you'll see some of them here and up there. The respondent, now the case is looking pretty strong for the complainant here, right? They had a pre-existing trademark, public company, New York Times coverage, respondent offered to sell for much more than out-of-pocket expenses in the 5 figures. Let's see what the respondent had to say. Respondent says it's a professional domain investor. They registered the domain name because it's a combination of 2 dictionary terms, and as such, it was of value to them. They purchased it at a public auction after it expired. In other words, previous registrant no longer wanted it, allowed it to expire. And they also provided evidence of other similar comparable domain names that they owned. Hydrogroup.com. Remember, we're talking Kronos Group, so hydrogroup.com, Gemini Group, Parkway Group, Visionary Group. So this was presented as evidence of we weren't targeting this complainant. We were registering this because it was an attractive combination of 2 terms. They said they did a search at USPTO for Kronos Group, and there were no trademarks. They did a WIPO search, and they said, well, there's all kinds of Kronos groups, Kronos trademarks by all kinds of companies all over the world. So this complaint doesn't have exclusive use over the term. They said there's a bunch of companies all over the world that have Kronos in their name as well. And of course, Kronos, not of course to me because I didn't study classics, but to those of you that have, you would be familiar with the fact that Kronos was the leader and youngest of the first generation of Titans. So there was another explanation for the selection of the word Kronos. The panel gave the complainant the first part of the test. Yes, they have a trademark. It's confusingly similar. The panel decided they didn't need to look at rights or legitimate interest. It all came down to registration and use of the domain name in bad faith. Now, if your panels, think about how you would be handling this case, and if your counsel, think about how you would have prepared this case if you're the complainant or if you were the respondent. We're going to see what happened. The panel said that their analysis must begin with an examination of the complainant's reputation. This is what I was alluding to at the beginning of how important reputation is. And the panel looked at whether under the circumstances present in this record, the respondent must have had actual knowledge of the complainant or its mark upon bidding for it. And actual knowledge is key to bad faith registration, absent that exception of willful blindness. But there's no such thing as constructive notice, generally speaking, in the UDRP. You must have been aware or be inferred to have been aware of the complainant's trademark. The panel looked at the facts and said, you know, this term Kronos and even Kronos Group is not exclusively associated with the complainant. They're not famous, really. It's not like a household item unless marijuana is in your household on a regular basis. It's not like, you know, Colgate or Palmolive or General Motors or something. It's in a niche market. The respondent denied awareness of its market. That seemed plausible in the circumstances. And that, yes, they did offer it for more than out-of-pocket expenses, but that's the nature of domain name speculation. You buy at a price and you sell it for more. And so there must be something more than just the price to infer bad faith from. And yes, they did get wrapped up in some other UDRPs, but they won some of them as well. And so we can't just look at that to establish bad faith. So the complainant didn't demonstrate why it had any greater right to Kronos Group than any of the other companies that use that mark in commerce. This is a crucial point because ultimately what the complainant had to prove here is that they were the target, the specific target of this respondent. The respondent registered this particular domain name because of this specific complainant. And so the complainant really failed to prove that they were the only reasonable target, considering there were other third-party users. In fact, the domain had been previously registered before it expired by somebody else. And so it was a non-exclusive phrase, and the complainant failed to provide sufficient evidence to show that they were were the primary target of this registration. The panel even found RD&H in this case. Remember, when we first looked at it, it seemed like a very strong case for the complainant. But at the end of the day, what the panel said is that they just brought this complaint saying, you know, we got a trademark, we're a publicly traded company, we've been covered in the New York Times. They offered it to us for thousands of dollars. But at the end of the day, what the panel said is that the complainant failed to provide sufficient evidence of its reputation such that we can assume or infer or conclude that they must have been the target of the respondent's registration. If you want to find out more about reputation, I encourage you to go to udrpperspectives.org. And I know that my co-editor of this, Igor Mocny, is a UDRP panelist with several providers and a fantastic Serbian IP lawyer. He co-authored it with me, udrpperspectives.org. You'll see that it covers amongst about over 50 issues, including reputation. You could read more about it there. Reputation is the key because it's the basis for targeting. Having a mere trademark alone is insufficient without proving that you were targeted. In order to prove that you were targeted, you need to prove your reputation such that it's more likely than not that you were the target for this particular registration. Constructive notice, although it's a concept that exists in trademark law, it's generally not accepted as an applicable concept in the UDRP because it doesn't look at intention and awareness. The material time for proving complainant's trademark, reputation in its trademark is prior to the domain name registration. And that's something that we often see complainants fail to do properly. They'll say, this is our reputation now. This is what was published last week in Forbes. This was the article that was written about us 3 months ago. That's not the material time. The material time is before the domain name registration. That's the evidence as a panelist you must be looking for. And where reputation is limited to a niche field, as it arguably was with this cannabis company, it's going to be more difficult for a complainant to prove its case. It's crucial to prove that the complainant's trademark and associated goodwill were the primary reasons for the response registration. And there's another case that I encourage you to look up. It's called Mengels, also 2024 case. A WIPO case that involved the same respondent also came to a similar conclusion. So for further reading, make a note to look up the Mengels case. And lastly, I encourage you, if you're interested in reading more about this and related subjects, to pick up a copy of Gerald Levine's The Clash of Trademarks and Domain Names. He was one of the panelists in this case, and I keep it on my desk. It's just off camera, but it's a very helpful resource. All right. That is the end of my presentation. Thank you for staying a few minutes late. Much appreciated. Back to you, Ina.
Yes, fantastic and wonderful. Thank you very much. What a rich and insightful presentations we experienced, and huge thank you for our experts for their perspectives. And to all, thank you once again for being part of today's session. And we look forward to continue this conversation and discussions, and look forward to seeing you in the future CIIDRC events. Thank you and have a wonderful rest of the day. Goodbye.